We have breaking news. Attorney General Bondi suggests that discussions of military plans in a unsecured chat was unlikely. That's a bunch of BS right there. Why did she suggest that the discussion of military plans in an unsecured chat was unlikely? Let's take a look at this brand new reporting by TJA. TJC. The article is headlined, Bondi suggests probe into Signal chat is unlikely despite a long history of similar inquiries. And ladies and gentlemen, the article reads, Washington Associated Press. FBI Director Kash Patel was not part of a Signal chat in which other Trump administration national security officials discussed detailed attacks, but that didn't spare him from being questioned by lawmakers this week about whether the nation's premier law enforcement agency would investigate. Kash Patel made no such commitments during the course of 2 days of Senate and House hearings, declining to comment on the possibility and testifying that he had not personally reviewed the text messages that were inadvertently shared with the editor-in-chief for The Atlantic, who was mistakenly included on an unclassified Signal chat. That Patel would be grilled on what the FBI might do was hardly surprising. Even as President Donald Trump insisted it's not really an FBI thing, the reality is that the FBI and the Justice Department for decades have been responsible for enforcing Espionage Act statutes concerning the mishandling, whether intentional or negligent, of national defense information like the kind shared on Signal, a publicly available app that provides encrypted communications but is not approved for classified information. The Justice Department has broad discretion to open an investigation through Attorney General Bondi, who introduced Trump at a Justice Department event this month, signaled at an unrelated news conference on Thursday that she was disinclined to do so. She repeated the Trump administration talking points that the highly sensitive information in the chat was not classified, though current and former U.S. officials have said the posting of the exact launch times of aircraft and times that bombs would be released before those pilots were even in the air would have been classified. She also quickly pivoted to two Democrats, former Secretary of State Hillary Clinton and former President Joe Biden, who found themselves under investigation but never charged for allegedly mishandling classified information. Indeed, the department has conducted multiple high-profile investigations in recent years, albeit with differences in underlying facts and outcomes. Multiple high-profile figures have found themselves under investigation in recent years over their handling of government secrets, but the differences in the underlying facts and the outcomes make it impossible to prognosticate. Sorry. Ladies and gentlemen, that was a hard one. I don't know why, but it was. What might happen in this instance, or whether any accountability can be expected. There is also unprecedented for the public officials either to avoid criminal charges or be spared meaningful punishment. In terms of prior investigations, there were set out standards that the department always looked at and tried to follow when making determinations about which types of disclosure they were going to pursue, including the sensitivity of the information, exposed the willfulness of the conduct, said former Justice Department prosecutor Michael Zwiebek, who has handled classified information investigation. A look at just a few of the notable prior investigations. Hillary Clinton, the 2016 Democratic presidential nominee, was investigated but not charged for her use of a private email server for the sake of convenience during her time as Secretary of State in the Obama administration. There appear to be some parallels with the Signal chat explode. The politically fraught criminal investigation was initiated in 2015 by a 2015 referral from the intelligence agency's internal watchdog, which alerted the FBI to the presence of potentially hundreds of emails containing classified information on that server. Law enforcement then set out to determine whether Clinton or her aides had transmitted classified information on a server not meant to host such material. The overall conclusions were something of a mixed bag. Then FBI Director James Comey, in a highly unusual public statement, asserted that the Bureau had found evidence that Clinton was extremely careful in her handling of classified information, but recommended against charges because he said officials could not prove that she intended to break the law or knew that the information she and her aides were communicating about was classified. The decision was derided by Republicans who thought the Obama administration Justice Department had let a fellow Democrat off the hook. Among those critical were some of the very same participants in the Signal chat, as well as Bondi, who, as Florida's Attorney General, spoke at the 2016 Republican National Convention and mimicked the audience chant of "Lock her up." David Petraeus. Among the biggest names to actually get charged is Petraeus, the former CIA director sentenced in 2015 to 2 years probation for disclosing classified information to a biographer with whom he was having an extramarital affair. That material consisted of 8 binders of classified information that Petraeus improperly kept in his house from his time as the top military commander in Afghanistan. Among the secret details in the Black Book were names of covert operatives, the coalition war strategy, and notes about Petraeus' discussions with President Barack Obama and the National Security Council. Prosecutors have said Petraeus, a retired 4-star Army general who led U.S. forces in Iraq and Afghanistan, would wound up pleading guilty to a single misdemeanor count of unauthorized retention and removal of classified material as part of a deal with the Justice Department prosecutors. Some national security experts said it smacked of a double standard for its lenient outcome. Comey himself would later complain about the resolution, writing in a 2018 book that he argued to the Justice Department that Petraeus should have also been charged with a felony for lying to the FBI. A poor person, known person, say a young black Baptist minister from Richmond, would be charged with a felony and sent to jail, he said. Joe Biden and Donald Trump. These investigations don't bear much parallel to the Signal episode, but nonetheless serve as examples of high-profile probes launched by the department into the mishandling of classified information. Both found themselves investigated by the Justice Department special counsel, with Trump being charged with hoarding top-secret records at his Mar-a-Lago estate in Florida. Trump had taken those records after leaving office. He was also accused of showing off a Pentagon attack plan to a visitor at his Bedminster Golf Club. The case was dismissed by a Florida-based judge, illegally my editorial edition, who concluded that special counsel Jack Smith had been improperly appointed. Prosecutors abandoned the case after Trump won in November. Biden, too, was investigated for his intention of classified information in his home following his tenure as vice president. A special counsel found some evidence that Biden had willfully retained the records, but concluded that criminal charges were not merited. Jeffrey Sterling, a former CIA officer, Sterling was convicted of leaking to a reporter details of a secret mission to thwart Iran's nuclear ambitions by slipping flawed nuclear blueprints to the Iranians through a Russian intermediary. He was sentenced in 2015 to 3.5 years in prison. A punishment whistleblower advocates and other supporters decried as impossible to square with Petraeus, misdemeanor found guilty. Misdemeanor guilty plea just a month earlier. The details of the operation disclosed by Sterling were published by journalist James Risen in his 2006 book, State of War. Sterling was charged in 2010, but the trial was delayed 4 years, in part because of legal wrangling about whether Risen could be forced to testify. Ultimately, prosecutors chose not to call Risen as a witness, despite winning legal battles allowing them to do so. Well, ladies and gentlemen, again, Pam Bondi lied like she always does. That is going to do it for today's legal breaking analysis reporting video. If you did enjoy this legal breaking analysis reporting video, please make sure that you like, comment, share, subscribe. If you want to make sure that you never miss a brand new video, please make sure that you smash the bell icon that is right next to the subscribe button down below on the right hand side. It does not cost anything. It's completely free, and make sure you hit the all icon options, instead of the personalized options. That way you're notified of every single breaking legal analysis video. Secondly, ladies and gentlemen, if you also want to make sure you never miss a brand new legal breaking analysis reporting, please follow me on my social medias down below. I'm on Instagram, Snapchat, and Threads. There you guys can be notified as well as via the bell icon when I post a legal breaking analysis brand new video to the channel and reporting update. Lastly, ladies and gentlemen, please help me reach and achieve the goal for the channel of 150 plus subscribers. The reason why I'm saying 150 plus subscribers is because right after we reach and achieve the goal of 150 subscribers, we have more subscribers to reach and achieve right after we achieve and reach the goal of 150 subscribers. Until my next reporting, ladies and gentlemen, please stay safe, please stay positive, and know that justice will prevail despite Donald Trump and his illegal administration's illegal efforts and unconstitutional illegal executive orders.